Okay, let's get started. Once again, welcome and thanks for joining today's session, ProbateCash Townhall Ask the Experts, a webinar brought to you by ProbateCash. Again, today we really want it to be about you and your questions. So if you have a question, please type it in the chat window. Your question will be seen by presenters, but not by other attendees. If your question is case specific or confidential, let us know and instead of addressing it here, someone will contact you later. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals awaiting inheritance payouts. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for 25 years, involved in purchasing over $100 million of assets. Most of his purchases, pursuant to various state laws, required court hearings, many of which Marc either attended or appeared as counsel. As the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts.
Good afternoon, everyone. I'm glad there are a lot of people here. We have a lot of questions, so we'll get to that. I may answer some of those questions right now, but so while Karen talked about what an inheritance advance is, I'm going to really briefly explain what it isn't. So we're not talking about interest in life insurance on our property owned by someone still living. Thus, we're not talking about buying senior settlements or remainder interest in real property. Those are different businesses. It's not what we're discussing today. Second, these are not intended to be transactions where we buy an heir's entire position or interest. The goal here is to provide the recipient with interim cash to meet their current needs while still keeping the heir in the game, looking forward to the ultimate wind-up and distribution of the estate. We want the ultimate settlement of the estate and distribution to remain of interest to and a priority for the heirs that we're funding. Finally, this is not a loan. There's no fixed due date, no interim payments or principal or interest due, no stated rate of interest, fixed or variable, no personal liability on the part of the recipient if the estate turns out to be insolvent or if the proceeds distributed to the heir come up short of what was originally anticipated. The only situation we'll have a claim against the recipient is where the estate pays out, the recipient gets a hold of their inheritance and simply doesn't pay us. That's just stealing. Someone flat out lied in the first place. That's fraud. In those instances, we'll try to get our money back. But if property sales are disappointing or the amount of outstanding debt eats up the proceeds or it all ends up taking years for distribution, that's just simply our risk.
Michael also had two questions. So he also asked, if the person got a will and the estate sends it to the administration, can that affect the situation?
I'll try that. Thanks, Michael. If the person got a will, so I'm assuming that you're maybe asking whether or not initially somebody passed away intestate. That could be one group of people who are getting an inheritance. If a will is subsequently determined to have been found and sent in, then that would affect of course, potentially affect who's going to be getting an inheritance. So in that case, yeah, it would affect the situation as far as, number one, who's the beneficiary, number two, what is their share, and in turn, how much of an advance could we provide somebody based on the share if it went from an intestate situation to a will, changing the who's entitled to what. Michael, if that's not the question you asked, definitely you can clarify that, or I may have misinterpreted it. You can send it on the chat.
Great. And thanks, Michael, again for those questions. And now we have one from Joel from California. And he asks, he wants to know the current minimum and maximum loans and interest rates.
Pointed out it's not a loan, so there is no interest rate, but we do charge fees. And we charge fees usually every 90 days with a cap after a year. Now, Joel, you're from California. California happens to be the one state where there's a statute right on point on assignments of inheritance. And it's the only state in the country that specifically has assignment, a law governing how one assigns an inheritance. I have a handy, of course, and Karen may be able to put it up there. It's California Probate Code section 11604.5. And that statute is a consumer protection statute, as you might be able to surmise. Everything from the font we must use on the contracts, be very clear of the payment amounts that are being that we're paying and what must be repaid. As far also on repayment, the California statute doesn't really have a maximum fee that can be charged. Instead, it goes with the old vague unconscionable. I can tell you that thus far in California, and I don't think there are any appellate decisions, but the probate courts, when there's been a challenge, is upheld that over 100% of the principal is reasonable. And, the court understands that these are non-recourse, that companies like us, ProbateCash, will make in advance, even sometimes before probate is filed. But at the initial stage, we make the advance before the claims period. So we do take significant risk. So I do encourage, and I saw Karen post the statute, that you can take a look at the California statute, a little bit of homework for you. It's actually very informative. And even though California is the only state that has a statute governing inheritance assignments, we actually follow the spirit of that law in every other state. So we use the same documents, same disclosures. We file the assignment of the inheritance with the court. So the probate judge, the estate attorney, always knows about these transactions. There's full transparency with all of our advances.
Oh, great. Well, thank you, Joel, for that question. And thank you, Karen, for posting that code right in the chat for everyone to look at. And we also now have two questions from Jeffrey from Illinois. And the first is about referral fee agreements from PI attorneys and to referring attorneys. Okay.
Thanks, Jeffrey. So the referral fee agreements, again, let me make sure I'm clear. And if I'm not, please feel free to put in the chat. I went to public school, so you got to bear with me, guys. So the referral agreements from PI attorneys to the referring attorney should not affect anything about our ability to make an advance. The fact that there is a referral fee, we're just is irrelevant. We're looking at the assets that are flowing through the estate. If we're talking about a potential referral fee, we would have to deduct that amount. I mean, if there's a personal injury attorney and there was $1 million verdict that was going into the estate, or $1 million settlement that was going into the estate, it'd probably be safe to say a third of that may not go into the estate. And so that would just change the amount of money each beneficiary may be entitled to receive, which would in turn change the amount of money we're willing to advance. And, as I said earlier, our goal is to make sure that all the beneficiaries have skin in the game. And so if somebody is looking at $100,000 inheritance, we are not advancing them anywhere near that amount. We want to make sure that they're motivated to cooperate and wind up the estate and receive their inheritance.
Okay, great. Jeffrey also asked, what are the other advantages for an estate as a penalty for using probate to settle the estate?
Okay, so I'm looking at that question. Because I know the answer to it, I'm going to say that what are the advantages for an estate is the penalty for using ProbateCash to settle an estate. Again, if that's not the question, you can correct me, but why do people need our services? Other than, of course, people would rather have money today than not. But there are actually many practical reasons. So usually when, as a lot of you know, a house is going to be sold as part of the estate. That's usually the major asset of the estate. And as a lot of you know, oftentimes the house is not really ready to be sold because it requires repair. So number one, we often give advances to beneficiaries so they can use the money to fix up the house. $20,000 of repairs could make a $400,000 sale price turn into a $500,000 sale price. Very important. Same as making sure back taxes are paid. Other kind of debt associated with the house. So in that situation, it benefits all the beneficiaries to be able to get the most money to sell the assets to enable the beneficiaries to maximize their inheritance.
Great. Thank you, Jeffrey, for those questions. And now we have a two-part question from Ben in Alabama. And he asks, do all the heirs need to apply for an advance, or can one apply? And do the others need to know?
It's important that everybody knows, because especially if you're representing an estate, if one beneficiaries are probably calling you often to say, how come this is taking so long for me to get my money? And your office is inundated with those calls, and we understand that that's one of the attractions attorneys have of our company. You can refer them to us and we can provide them with an advance. Hopefully the phone stops ringing at that part. But what you need to know, why this is an important question, is that because one beneficiary needs an advance, whether or that advance to the one beneficiary does not at all adversely affect any of the other beneficiaries of the estate, and nor should it affect the timing of the assets to be paid out of the estate. We enter into a contract with the one person who needs the money or requests the money, and that's it. So it could be seen in the court filing because it's an assignment of an inheritance. However, for instance, if the house sells and somebody owes us $50,000, but their share is only 40, we will get the 40,000 from the beneficiary who received the advance. But the $10,000 shortfall will not be the responsibility of anybody else. That's our risk. So none of the other beneficiaries have that. So it's important that you know that when you're counseling your client or talking to other beneficiaries who are concerned because a sibling or another beneficiary of the estate needs an advance.
That's good to know. And thank you, Ben, for your question. And now Deborah from Nevada asks, if I have a client I think would benefit, what would be the best way for me to get the info to y'all? It's probably a great time. I know I put in the chat, but I'm going to give you guys Marc's contact information. You can call Marc at 561-476-0018. You can email him at marc@probatecash.com, and that's MARC@probatecash.com. But let's get back to y'all's questions. And thank you, Brian, for that question. So Brian, then the next question is from Brian. And Brian from New York says, providing cooperation can take time. Will ProbateCash reimburse the trust for my time?
Thanks, Brian, for that question. And Molly, I'm sorry, it often sounds like one of those infomercials, but Molly does a pretty good job making it sound much more natural. So anyway, that's a good question. And I know as a lawyer, and my wife's a lawyer as well as anyone, that, we're not selling clocks here, we're selling time. And not to mention that your cooperation with us in determining whether to provide an advance. So we do our own independent underwriting, but we always like to confirm that you may have knowledge about the estate that we don't, or something coming down the pipe. And so not only are we willing to pay an hour of your time for working with us, but the more we know from talking with you as counsel for the estate, we may be able to also adjust our fees accordingly, because our high fees reflect the risk involved in a non-recourse advance. And if we feel better that we're going to get paid back, then I will justify the rates or advance fees accordingly.
Great. And thanks again, Brian, for that question. And now we go from Joseph from Missouri. And he asked, how do I handle repayment, and what's the timeline for closing?
The beneficiary can really repay us anytime. They don't have to wait till the estate closes. If they want to repay us early, have the means to do so, that's fine. So no prepayment penalties or anything like that. In fact, quite the opposite. The earlier they pay us back, the less fee it would be to them.
Yep. Well, thanks, Joseph, for your question. And we also have a question from Juan from Texas, and he asks, if an heir comes in for a consultation and does not have the money for retainer fee, is that something they can use your service for?
Yeah, thanks, Juan, for that question. And that actually happens, I don't know, more than you think, but it does happen. So a lot of lawyers, just like everybody else in any business, the marketing, using search engine and other types of marketing. And so the potential clients that are coming to see you and want to open up probate don't have the money to pay a retainer fee to open up probate. And while a lot of lawyers are able to wait until the estate settles before getting paid from that distribution, other lawyers definitely want to have a cash flow coming in. So we work with a whole bunch of lawyers who, as they're bringing in customers, what we ask them to do is at least have a consultation with them. We want to confirm there are assets to the estate. Usually the house is that would be the asset, that house is going to be sold. And, if we have that information, we will advance the beneficiary, usually the person who's going to apply for the letters, will make an advance. That beneficiary will authorize us to pay that advance directly to you as attorney, as the retainer fee. And oftentimes there's more costs and subsequent advances. And so we have felt all parties, it's a win-win-win. The beneficiary is able to open up the probate. The lawyer is able to have cash flow, not having to wait till the end of the probate before getting paid. And we enjoy working with that arrangement because we are also working with you guys. And during that, of course, the beneficiaries often get a little bit more money, so we should be able to advance money to not just pay the fees, but if the beneficiaries need money to fix up the house for sale, whatever those needs are, we can do that. So that's a very common relationship that we have with lawyers throughout the country.
Right. Seems like it works for everyone there. So thanks, Juan, for that question. And now Charles from California asks, what due diligence do you do? Thank you, Charles, for that question. We also have a question from Sarah in Florida. As an attorney for an estate or a trustee, can I be held responsible if I talk to your company or about an advance, or if you don't get repaid?
Okay, a fellow Floridian, Sarah, thanks for that question. So, in short, no, right? You're not violating any attorney-client privilege or committing fraud yourself. No, where would the liability be? In fact, if you're concerned about it, this is how confident I am, ProbateCash is even willing to provide you with an indemnity for that purpose. So if you referred your client or a beneficiary of the estate to us, and you were nervous about doing that, but you knew they needed to get paid, or needed an advance. A lot of probate lawyers intentionally avoid litigation. That's why they're in probate. And I understand that more than anything. I'm an attorney here in-house and in the CEO position, or I'm not in the courtroom, or hopefully not in the courtroom. And so I totally understand it. We would provide an indemnity for you in that situation. But what I recommend is when somebody needs money, you tell them contact ProbateCash. By the way, again, run by an attorney. I understand what it's like to have clients, to be made to look good in front of those clients. Certainly not give advice to the client that is going to make you look uneducated, or not having their best interest in mind, even if it's just a beneficiary and not your client. So I don't see any liability, and it's up, really, at the end of the day, it's up to the beneficiary, who has to determine whether or not they want to agree to our terms. If we don't get repaid, we're not coming after you, the attorney. We understand the risk, and we're in a risky business sometimes. You never know what a probate is going to do. They're very unpredictable, and that's our business. So I think you're safe. And like I said, if you feel free to talk to us, and we'll also certainly consider indemnifying you with that.
Yeah, she can reach out to you, it sounds like. So thank you, Sarah, for that question. And Tim from Hawaii asks, what's the process for a client to get a probate advance? What's the timeline?
Certainly, I want to emphasize the cooperation we receive from probate attorneys. If you're representing the estate, and we know your attorneys, and you're saying that there's money that's going to be flowing through the estate and we're going to get repaid back, which we've had that cooperation from estate attorneys, we can give the advance in the same day. So I don't want to underestimate the importance of the cooperation from the estate attorneys to supplement our underwriting.
Thank you, Tim, for that question. And then Catherine Aravon asks, my client set up a trust, but one of the beneficiaries of the trust needs an advance. Do you deal with trusts?
Yes, we do. We absolutely deal with trust. Now trusts are tricky because most of the trusts, of course, have spendthrift provisions. We will work with the trust. We want the trustee to be on board. That is the one time we get somebody additional. And so if there's one beneficiary of the trust wants an advance, we want to make sure the trustee is aware of the advance. The trustee will make the repayment. And specifically, we acknowledge that there's spendthrift language in the trust, and we ask the beneficiary and the trustee to waive that spendthrift provision for the purposes of repaying us back. We often operate that way with trust, and so far that's been fine. Of course, we also like to talk to the attorney involved as well with the trust, so everybody's on board if the trustee is not a corporate trustee.
Great. And we got all our advanced questions in. We have one of our web chats from Tyson. So thank you, Tyson, for asking. What is the best way to refer people? Do you prefer online contact, phone, flyers?
So I'm 50 something years old, so I like old school. I like a phone call. And you can call me or you can email me. I can handle that too. Karen's a lot more younger and hip than I am, so there's probably multiple ways to contact her to refer. But I always like the approach of getting a phone call so I can get as much information as possible and get a feel for how the transaction is. But I think there's no magic way. The important part is we get the information, who's getting who's requesting the advance, what approximate amount of the advance, where are we in the probate, if have we started the probate, for instance, or are we in the claims period, the usual pertinent information.
That makes sense. And I'm going to make sure we got to everyone's questions in the chat. You can still ask them now. It looks like we have. Now, if you're like me and you think of the question in 15 minutes, an hour later, please feel free to email Karen, Mark, anytime. So I'm going to give their contact information to you one more time. You can call Karen at 561-242-3082. Or you can email her at Karen@ProbateCash.com. You can call Mark at 561-476-0018. You can email him at Mark, that's MARC, @ProbateCash.com. We're also going to be sending up a follow-up email with an e-brochure for ProbateCash and a link to this webinar. And again, I want to thank everyone for sending their questions in advance and for sending them in the chat and really helped make this webinar possible. So thank you again for all your great questions and for joining us today.